you will know over a period of time that we love our state. And we will only do and only advocate for what's in the interest of the state of Texas. So I would use this as one more example where I think this legislature needs to have a reckoning on its relationship with the judiciary. And I would say to you, just as a matter of foreshadowing, the judiciary next year will recommend changing who can practice law in this state, and recommending that people that are not lawyers be able to practice law. And they have a committee working on that now. And as you may know, on behalf of the family lawyers, we stuffed them pretty good one year when they tried to do some things that had frankly, the court practicing law itself. So I think there's a need for it. I sometimes feel like there's only a few of us crying in the wilderness about this. But I think you'd be doing the state and everybody a favor if you'd revisit the relationship between the legislature.
I want to go back to the access to justice issue. Judge Gonzalez, if we have some suggestions, especially with regard to family law, and especially in light of some of the comments today, where obviously some people just don't like lawyers.
To the committee, and do you have comment on 4.03?
Yes, good morning, everybody. Just a quick comment on Rule 4.03. I think the addition that that they're not giving legal advice to an unrepresented person, I think that's good. However, I don't think the addition of the other than advice to secure counsel, I don't think that's really necessary in this. In fact, in some cases, based on the commentary of others, I believe securing counsel is not always in the best interest of that, say, a pro se litigant or somebody who cannot afford an attorney. That seems useless and often detrimental to their needs. So I would think that just leaving it at not giving legal advice to an unrepresented person would be sufficient.
That's a good point, and I'm glad you raised that. Let me ask you this. Do you think telling someone they need to hire a lawyer is giving legal advice?
I believe it is. It's a kind of advice telling them that a lawyer is the one who will be able to serve their interests, and I believe that's a legal advice there.
Okay.
And I just think, like I said, I don't think necessarily hiring an attorney is always in an individual's best interest, and to advise them as such would be potentially detrimental to that individual.
Okay. All right, very interesting. Anybody else from the committee have a question for Mr. Champagne? Oh, good. Well, thank you so much for taking the time to join us and give us this perspective. I appreciate it.
Thank you very much. Have a nice day. Bye.
Thank you.
It may be a good idea to include in the requirements that a litigant has gone through at least 2 lawyers, because obviously it has not been a satisfactory experience. And so it may be that some people at least would perceive that they are better served by non-attorneys. So if we wanted to talk to the committee about just putting some parameters around that, should I?
Do you mean like before they were to go to a paraprofessional, whether supervised or unsupervised,
right,
requirement for that particular client to go through 2 lawyers?
Well, this is obviously not a well-crafted thought, but if there's a checklist,
right,
when you go into the doctor's office, if there's a checklist, I think it would be beneficial to pro se folks, as well as the Access to Justice committee, to consider whether or not they've actually used lawyers in the past.
That's not we're trying to get data. And so just kind of having the idea of, did you go to a lawyer before you had to come to a paraprofessional? And if so, how many did you contact? And what were the reasons maybe why you weren't able to secure that lawyer?